Welcome. I am Greg Peterson. I'm the president of the Robert H. Jackson Center. The Robert H. Jackson Center is designed to preserve the legacy of Justice Robert H. Jackson. Today is a continuation of events to accomplish this goal. During our short 5-year period, we've been privileged to host such roundtable events as Nuremberg prosecutors who were with Justice Jackson during a time period of which we've now celebrating the 60th anniversary of the commencement of the Nuremberg trials. We've had the Robert H. Jackson law clerks of the 1940s. We've had the Robert H. Jackson law clerks of the 1950s, of which we have one in attendance today, E. Barrett Prettyman, who will be welcoming you in a few minutes. We've had the law clerks involved with the Brown versus Board lawsuit. We've had the law clerks involved in Brown versus Board 2. And we had a day with Fred Korematsu, the named petitioner in the very famous case of Korematsu versus the United States. And we've been privileged with being blessed by having Chief Justice Rehnquist here in 2003 to dedicate this facility, among other events we've had. And we thank the community and we thank all the sponsors who really made that possible. Consistent, and as we are on our 5th anniversary, pause on this, but consistent throughout these events have been an effort to preserve the legacy through education, exhibitry, and the relevance of Robert H. Jackson's ideas for our generation. And also consistent throughout that 5-year period and these events have been the fact that they've been moderated and led by and inspired by Professor John Barrett. More on him later. And we thank John for all of that. A few housekeeping matters, as I mentioned earlier, because we are videoing this for future broadcast and potentially on C-SPAN. Please turn off your cell phones. There'll be no Q&A at the end of this. It will be concluded by me. Also to mention the fact that there are books which are available, which have been authored by Sean Francis Peters, who will be presenting here in a few minutes, entitled Judging Jehovah's Witness, as well as Professor Barrett's extremely well-received book, That Man, of which he edited Robert H. Jackson's recollections of Franklin Roosevelt. This event does not occur without the support of our sponsors, who I'd like to just recognize at this time. HSBC Bank and Janice Burkhouse, Lloyd & Company, the folks at Serta Mattress of Jamestown, the Young Title Agency, the Post-Journal, Steve, thank you very much, Allegheny Financial Services and Brian Waranowski, Jamestown Bar Association, its president Arthur Bailey, the Jamestown Chamber of Commerce, Rich Fisher, and the Jamestown Community College. The order of the day will be, I'll conclude here in just a second, but also give you a little background on E. Barrett Prettyman, who will be welcoming you on behalf of the other co-sponsor, the Supreme Court Historical Society, and we're thrilled to have that relationship with them. I'll also be introducing Sean Francis Peters, who will be giving an overview of the activity in the Supreme Court leading up to the Barnette case. I'll be then introducing Professor Barrett, who will also then be introducing the panelists, and we'll conclude at the end. At this point, I would like to, we'll be bringing to the podium E. Barrett Prettyman, Jr. of Washington, D.C. He's a graduate of Yale University and the University of Virginia School of Law. Mr. Prettyman was Robert H. Jackson's final law clerk. And after Jackson's death, Mr. Prettyman served Justices Frankfurter and Harlan. Following his clerkship, he joined Hogan and Hartson law firm in Washington, D.C., where he is now of counsel. He's the president, or vice president, and trustee of the Supreme Court Historical Society, and has written a book and several articles on the Supreme Court practice. He's also a co-editor of a book by Justice Jackson on the Supreme Court. Before I bring him up, I'd like to also introduce Sean Francis Peters, who's the author of Judging Jehovah's Witness, an award-winning book about the subject, and he will be giving you the overview. Mr. Peters has taught at the universities of New Hampshire and Iowa, and currently is with the University of Wisconsin-Madison School of Journalism and Mass Communication. This time, I'd like to introduce E. Barrett Prettyman, Jr.
Thank you so much. I am so proud to be a member of the board, new member of the board of the Jackson Center, and also vice president of the Supreme Court Historical Society. The two organizations have sponsored events before, all of which have gone extremely well, and we love to do business with these people because they don't just talk or plan, but they actually do things, get things done, as evidenced by this large crowd and these wonderful guests today. At first glance, it might seem that the Supreme Court Historical Society and the Center do entirely different things in the sense that the Center focuses on one man, a man, incidentally, who's a great hero of mine, a very important figure in my life, Justice Jackson, whereas the Society focuses on the Supreme Court as an institution. But at second glance, you know that the institution is really the story, the history of a great many men and a few women who have sat on that court. And so both are really focusing on the same thing, except one man here and many people there. But again, welcome to you all. We're so glad you came. And to our guests, I'm as excited as you are. Thank you.
Good morning. Some of us are great in stature. I am merely great in height, so I might have to adjust the microphone here. I have to be honest, I love events like this. They give us an opportunity to look at the judicial system in general and great cases in particular from new and interesting and varied perspectives. I think sometimes we look at judicial opinions as these fully formed, perfect entities that sort of magically appear from the Supreme Court. And while I agree that they are the products of great learning, they're also the products of social, political, cultural, and even idiosyncratic personal forces as well. And it's one of the things that will happen today. I'll talk about that. And I'm, for one, looking forward to the main event, which will be looking at those forces as they shaped West Virginia versus Barnette. My job is to provide a little bit of background, sort of what happened before 1943 and the Barnette flag salute case. And the first thing that I'd like to talk about is just the Jehovah's Witnesses and the Supreme Court. Between 1938 and 1946, the Supreme Court handed down 23 opinions dealing with the Jehovah's Witnesses. It's an enormous number of cases for such a short period of time. I think of that when I go to my local coffee shop and I get a little punch card every time I refill my coffee, and I've thought that the witnesses might, if there had been a sort of frequent litigant program, that the witnesses would have filled up their cards quite frequently. And it's worth noting, too, that the cases that reach the Supreme Court are the sort of top of the litigation pyramid, and it's important to look at lower levels as well, lower federal as well as state courts. And in fact, during that same period, the witnesses were involved in hundreds of cases, not just 23, hundreds. And they involve some really profound issues: speech, religion, freedom of assembly, freedom of conscience in the context of military service. These were really important, not only for the witnesses themselves, but more broadly for all Americans. It's important to realize the court today we think of as being concerned with civil liberties and civil rights, and you can pick up the paper frequently and read about the court sort of rendering judgments in these matters. That was not always the case in the 19th century, and well into the 20th century, the court was concerned primarily with economic regulation and not civil rights and civil liberties. That's a phenomenon of this, or of the 20th century. The witness cases are important because they made the court think about those things for kind of the first time. In the 60s, there was something that has been referred to, that started in the 60s, the rights revolution. And one of the things I argued in my book, and I still believe very fundamentally, is that the witness cases sort of set the stage for that rights revolution in the 60s. By going to the Supreme Court over and over again, they made the justices sort of wake up to the Bill of Rights in a way that they hadn't previously done. And my favorite quote relating to this is from Justice Stone, and this is before he became Chief Justice. He wrote to a colleague, "I think that the Jehovah's Witnesses ought to have an endowment in light of the aid they give us in solving the legal problems of civil liberties." And they didn't get their endowment. I think that that was a sort of joking suggestion, but it highlights the fact that the members of the court themselves sort of realized this transformative process that they had experienced in the 30s and 40s because of the Jehovah's Witnesses. What I'll do is just talk briefly about some of those cases. I'll let the experts talk about West Virginia versus Barnette, since they know much more than I do, and set the stage for that case. And the first question is, sort of, why were there so many Jehovah's Witness cases in the 1930s and 1940s? And there are a lot of reasons. I'll highlight a couple. I wish I had more time to sort of explore the rich and fascinating history of the witnesses as a people. One thing that sort of stands out, and I think is important to realize, is just address the matter of what is religious worship for members of various faiths. And the witnesses, in many ways, like many Christian denominations, trace their origins back to the apostles and the apostolic era. And the apostles were nothing if not active. They had a very public ministry, preaching the gospel amongst themselves, but also going out among the people and sort of hitting the bricks. And in the 1930s and 1940s, the witnesses carried on that tradition in a very, I think, unique and interesting way. For them, worshiping was going forth, distributing tracts, preaching on street corners, selling Bibles, doing all of this very sort of public work in a way that other churches didn't do, preaching the gospel that way in the public sphere. Secondly is the matter of the flag salute, which I'm sure our guests will talk more authoritatively about. The witnesses came to believe that the salute to the flag was a form of idolatry. It was amounted to the worship of a graven image as prohibited by the scriptures. These two things, among others, had precipitated some conflict in the 1930s. Towns throughout the country responded to the public worship of the witnesses in restrictive ways. They sort of passed ordinances trying to prohibit people from distributing tracts. They attempted to regulate that religious practice. And there was also some rumblings regarding the flag salute. Was it sufficiently patriotic? Should school children be allowed to opt out of the flag salute? These matters simmered in the 1930s, but they really came to a boil in 1940. Now, as you all know, the United States didn't formally enter World War II until 1941. However, the war in Europe had started long before that. And in the spring of 1940, there had been a period in the winter of 1939/1940 that had been known as the phony war. There was this sort of lull in the fighting in Europe, and people weren't sure sort of what was going to happen. By the spring of 1940, people knew the Nazis were on the march. The Low Countries fell to the Nazis, and France fell to the Nazis as well. And people in the United States were keenly aware of those developments, even though the United States wasn't involved in the war. And one of the things people wondered about was, how were the Nazis so successful in essentially overrunning the European continent? One of the explanations was that spies, saboteurs, and fifth columnists had helped the Nazis prevail in Europe. And in the United States, in ways that sort of parallel our current situation with the war, people started looking for internal enemies, and one of the groups that they latched onto were the Jehovah's Witnesses, primarily because of the flag salute issue. It was perceived as being unpatriotic. Now, if you know a little of the history of the Witnesses, this is incredibly ironic. Witnesses are being persecuted in Nazi Germany and forced into concentration camps because of their refusal to offer the Hitler salute. So they're being persecuted in Nazi Germany and then being perceived of as traitors in the United States. It's very incongruous, but unfortunately, it is what happens, starting primarily in the spring of 1940. Matters come to a head in June of 1940 with a case called Minersville School District versus Gabaitis. It's the first flag salute case. It's what's known as the first flag salute case. It's the forerunner to the Barnette case that we'll hear more about later. And the Minersville case originated in a town in Minersville, Pennsylvania. Some young witness school children were expelled from their public school for refusing to salute the American flag. And the legal issue in that case was, were their First Amendment liberties, their religious liberty, were those freedoms violated by the application of the school regulation to them? And I'll point out that the factual sort of background of the Minersville case and the factual background of the Barnette case are in many ways parallel. However, those legal issues, as the court sorted them out, were different. The Gabaitis case is decided primarily as a religion issue, and the Barnette case is decided somewhat differently. And again, we'll hear more about that later. In June of 1940, the court rules against the witnesses in that Minersville flag salute case by an 8-1 margin. It's a really resounding defeat for the witnesses. Justice Stone is the only justice to dissent. The other 8 in the majority are led by Felix Frankfurter. And many people at the time were surprised that Justice Frankfurter had written this decision. Frankfurter was known as a firebrand liberal. He had defended in the 1920s Sacco and Vanzetti, these notorious Italian anarchists who had been charged with murder. He had been involved in numerous sort of civil liberties causes over the years. And in this case, it appears that he has sort of broken with his background. And Frankfurter's personal history is interesting, and the effect of the war on him in particular is really profound. Americans were afraid of the war. They were starting to think about the war. Justice Frankfurter in the spring of 1940 was really obsessed with the war. He was a European by birth, and in a way that profoundly influenced his interpretation of the first flag salute case, became concerned with the war. And that sort of shaped the way he viewed the issues in the case. And he believed, if I can sort of briefly summarize, that in periods of wartime, national unity is the most important thing, that the country really has to come together or there won't be any country to grant civil liberties. He believed in sort of, in these times of crisis, sort of subordinating civil liberties to the greater good. And in the clash that he has with Justice Stone is really a classic state power versus individual liberties. Justice Stone, in 1938, 2 years before, had written it's the most famous Supreme Court footnote. He had addressed the need to protect discrete and insular minorities. And so Justice Stone believed that especially in wartime, it's important to defend people in these minority groups. And the opinions that they write are very learned, they're very they're complex in many ways, and there's correspondence between these two justices as well, where they work out these ideas, and it's this very lofty process and very fascinating to read. Unfortunately, the public perception is not so lofty. When the opinion comes out, the general public sort of misinterprets the Supreme Court's conclusion in that first flag salute case. People throughout the country mistakenly believe that the Supreme Court has said that the Jehovah's Witnesses were traitors. That is inaccurate. The court never even came close to saying that, but that is the misperception that sort of takes hold in small towns throughout the country. And so what transpires is a really amazing public reaction to a Supreme Court decision. It's unparalleled in American history. Controversial decisions today, we have protests, people call, talk radio, they get mad. The first flag salute case, something of a different magnitude happened. There were actually violent attacks on Jehovah's Witnesses, mob attacks in places like Litchfield, Illinois, Rockville, Maryland, and Kennebunk, Maine. Witnesses are fired from their jobs. They're denied relief benefits. Children are expelled from schools. That is the one part that people sort of got right. The court had essentially given its approval to that kind of thing. It's a really it's an unprecedented reaction to a Supreme Court decision, and it's an unprecedented outbreak of religious persecution. Most people contemporaneously and subsequently have recognized it as the worst outbreak of religious persecution in the United States in the 20th century. And I'll read to you the attack in Kennebunk, Maine was a particularly grievous breach of civil liberties. A mob attacked a Kingdom Hall of the Jehovah's Witnesses and burned it more or less to the ground. And this is from the Boston Globe, its account of that persecution. The mob made 2 visits and set 2 fires. The first burned out part of the building's interior but was extinguished quickly. The second completed the destruction. Before each of the fires, the mobs ransacked the building and removed tracts, furnishings, and members' personal belongings. These were burned in piles in a street of this ordinarily placid town. And at the time, people are sort of horrified that this is happening. John Haynes Holmes of the American Civil Liberties Union coincidentally owns a summer home near Kennebunk, Maine, and so he's attuned to what has happened, and he writes and sort of protests this persecution. And John Haynes Holmes said, quote, "This sounds like the Jews in Germany, but it happens to be the Jehovah's Witnesses in the United States." Others commented as well. Eleanor Roosevelt was writing a newspaper column at the time. She commented on it. And the members of the Supreme Court became aware of this. They often, I think, create the perception that they are these Olympian figures who are sort of above current events and shut out what is going on. And I think in general that is not true. And in the case of the flag salute and the Jehovah's Witnesses, it was definitely not true. Immediately, 3 members of the Supreme Court realized what had happened. Justice Douglas, Justice Murphy, and Justice Black very quickly realized that they had made a mistake. And they did something that's really extraordinary. They publicly admitted that they had messed up. Which I know where I work. People don't do that frequently. I certainly don't. And members of the Supreme Court almost never do. And in a case that was decided between this Gabaitis case that I've been talking about and the Barnette case, those 3 justices wrote a little joint opinion in which they said that the first flag salute case had been wrongly decided. It's a really extraordinary public admission of their error. The mob attacks And the other forms of persecution sort of made them rethink Justice Frankfurter's opinion in that case. And they, to their credit, they fessed up rather quickly. And you can start doing the math in your head. The original decision in this first flag salute case had been 8-1. Justice Stone had been the one. Now, Justice Stone has 3 more people on his side. It very quickly becomes in effect a 5-4 rather than an 8-1. Other things happen that sort of affect the dynamic of the court. In the Roosevelt era, I think that you needed a kind of baseball scorecard to see who was coming and who was going. Justice Burns served for 1 term, and Justice Jackson joins the court, and before he had been Justice Jackson, he was Attorney General Jackson. And in that role, in 1940, he was aware of these mob attacks as well. He's the country's chief law enforcement officer. And so reports of these mob attacks and firings and expulsions are crossing his desk. The Justice Department has an embryonic civil rights section. It's not the most effective thing at that point. It's sort of brand new. But they're funneling information to Justice Jackson, so he knows what's going on. He publishes a book shortly before he joined the court in which he hinted at his disapproval for that first flag salute decision, in which the book was The Struggle for Judicial Supremacy, and he singled it out as an exception to the court's usual vigilance, quote, in stamping out attempts by local authorities to suppress the free dissemination of ideas upon which the system of responsible government rests. So the Gobaitis decision as an exception to that vigilance. He also later wrote in some other correspondence, quote, when I came on the court, I agreed with Stone that I didn't think the flag salute was constitutional. So he comes on the court. Now, Justice Stone has himself, those 3 other justices who had admitted their mistake, and Justice Jackson. That's 5, and that's all you need. They get a 6th, a justice named Wiley Rutledge had served on a lower federal court, and those many hundreds of lower court cases involving the Jehovah's Witnesses. He had also written unfavorably about the first flag salute case. So that turns the tables. It's now a 6-3 majority against the flag salute. And it's not surprising to me that the court changed its mind regarding the flag salute. It happens, people's ideas evolve, their perceptions evolve, their understanding of the values that the Constitution embodies evolves as well. What's striking is that it happens so fast. I've been talking about the first flag salute case, that was 1940. The court changes its mind in 3 years. It essentially reverses itself. I'm not aware of any other case that had been sort of vacated so quickly. If we think about the great civil rights decisions, or the infamous civil rights decisions from the 19th century, it took almost a century for the court to get there. In the case of the Jehovah's Witnesses, it happened much more quickly. It happened in only 3 years. Unlike the first flag salute decision, the second flag salute decision meets with sort of widespread approval. By 1943, the United States has entered the war, and after some rough going in the early part of the war is sort of going better for the United States. There's still a long way from victory in the Pacific or in Europe, but people are sort of less tense. Those fears of saboteurs and spies and fifth columnists have dissipated somewhat. So the Barnette decision is greeted more favorably, and my favorite account is from Time magazine, which in classic Time magazine fashion had a brief, concise article, and the headline of that story was "Blot Removed." And the remainder of our program, you'll hear from people explaining how and why that stain was expunged. Thanks.
Thanks, Sean, for setting the stage. And now I'd like to introduce Professor John Q. Barrett, Professor of Law at St. John's University School of Law, and he's been a member of the faculty since 1995. Professor Barrett's edited version of That Man, the late Supreme Court Justice Robert H. Jackson's previously unknown intimate memoir of President Franklin Roosevelt has been a big hit and critically acclaimed, and is also available for your consumption after we get done today. Professor Barrett is also writing a biography of Justice Jackson that will include the first inside account of his year away from the court as the chief American prosecutor of the principal surviving Nazi leaders at the International Military Tribunal at Nuremberg, Germany, of which there's been a great deal of celebration during this year being its 60th anniversary. Professor Barrett is also the first Elizabeth S. Lene Fellow at the Robert H. Jackson Center in Jamestown. John is a graduate of Georgetown University and Harvard Law School, and was from 1986 to 1988 a law clerk to Judge A. Leon Higginbotham of the United States Court of Appeals for the Third Circuit in Philadelphia. But more importantly, to the Robert Jackson Center, we call him friend, and he has been an inspiration and the moderator for all of our major events here at the Jackson Center. So I'm pleased to introduce John Barrett, who will now turn it over on the panel discussion. John?
Thank you very much, and hello. Welcome to the Robert H. Jackson Center in Jamestown, New York. I'm John Barrett, a professor of law at St. John's University and the Elizabeth S. Lene Fellow here at the Jackson Center. Our topic today is a great event of 60 years ago and today in our constitutional history, the Supreme Court's decision in the landmark case West Virginia State Board of Education versus Barnette. I'm very pleased to introduce three special guests and protagonists in those events who will be part of a conversation with me this morning that, of course, considers the law, the finished product, and the correct, I think all would agree, destination of this story, but the human realities of school children and lawyers and judges and law clerks that were part of the complicated path that was traveled to produce this landmark decision. Immediately on my left, the first guest I'd like to introduce is Marie Barnette Snodgrass, and to her left, her sister, Gaithy Barnette Edmonds. They've traveled from West Virginia to be here with us this morning, and they are the Barnette sisters, who were the leading alphabetical order names among the prevailing plaintiffs in that great case. It's a delight to welcome them to the Jackson Center.
Thank you.
To Gaithy's left, I'm also pleased to introduce Mr. Bennett Bosky. He's a lawyer from Washington, D.C., a graduate of Williams College and Harvard Law School. Following his sterling law school accomplishments, he became a law clerk, first to Judge Learned Hand at the United States Court of Appeals for the Second Circuit in New York City, then to Associate Justice Stanley F. Reed at the Supreme Court, and then, beginning in the summer of 1941, he served as chief law clerk to the new Chief Justice of the United States, Harlan Fiske Stone. Mr. Bosky served as Justice Stone's senior law clerk, senior of two law clerks, for the next 2 years of the court, a 2-year run that culminated in June of 1943 in the Barnette decision. It's a pleasure to welcome Bennett Bosky to the Jackson Center.
Thank you.
Let me begin with Gaithy and Marie, and the people who are really important, very important actors in the legal story and, of course, in your lives. I'd like to hear about your parents and your background and your family upbringing. Tell us about your parents.
Well, they raised us as Jehovah's Witnesses from birth, and that's where we grew up to obey them as and our God Jehovah and all their laws. And so we had a very nice childhood.
Had they been raised as Jehovah's Witnesses? Or
No.
was that something they came to in adulthood?
Yes.
They started studying about 1933 when I was infant.
Okay. What town were you growing up in?
Well, we lived close to Charleston, which is the capital of West Virginia. We lived in the country, about 5 to 6 miles out of town.
Okay. And as an occupation, what was your father's work?
He worked for E.I. DuPont, the chemical company.
Okay. Not a lawyer or a
No.
man of the law world. Was he a crusader on issues of rights?
Not really. He was just a faithful witness, and he believed in the Bible and what it taught. But he wasn't really a crusader. He was just a teacher,
Okay.
a witness.
Let me turn to your schooling. You're not twins, but I believe your schooling began around the same point in time. Tell me about that and the school that you began to attend.
Well, I started at an early age of 5, and Gaithy didn't start till she was 7 because of circumstances at home. And we first attended a little 2-room school in the country, and then we moved closer into town. And the year that the flag salute came up, we were going to another different school closer into Charleston because of the weather, you know, and we lived in the country, and so we moved in closer to town so that Dad could get to work easier and all the things that offered.
Right. What was the name of the school? And
Slip Hill Grade School.
Slip Hill Grade School. So it ran from the first grade up to what level?
6th grade, I believe.
The 6th grade. And how many students in the building?
It had 4 rooms, I think, 4 rooms of, and
So you went from a small school to this big school.
yes.
At Slip
it
Hill,
was
all
big,
4
yes.
rooms, okay?
Large.
And what's your memory? How many kids in a room is your memory?
Oh, probably about the average of it, even today, 25
Okay.
maybe kids.
Okay. Was there an American flag in the classroom? Was that the?
At first, there was just a picture of the flag on the wall until the war started, and they put up a real flag.
Okay. Had your parents alerted you to this issue of flag salute as you were beginning your school years?
Well, they just taught us that the purpose of our faith, which is give our devotion and worship to Jehovah God, and not to any image of any sort, and that we thought that it was taught that the bowing down of the flag, it was like a saluting it was like a bowing down and giving reverence to it.
Mm-hmm.
It's like an idol, and so we believe definitely not to worship idols.
Okay.
And of course, they were aware of what was going on in the world, and was aware of the other things that were happening. So I can't actually say I recall them telling us, but I'm sure they talked to us about what might happen and what our reaction should be to it,
Right.
and showed us the Bible proofs of what we believed in and what we should say.
Okay. Now, you were a precocious early reader, but I suppose you weren't reading about the Gobitis case.
No.
You didn't know this was swirling around? You're just a young girl going to school?
Not that age.
Okay. Bennett Bosky, you're a schoolboy and working up through the school. Do you remember flags in your classrooms, New York City?
Not really, but they may well have been there.
Okay.
But it was long before this.
That's true. That's true. Perhaps your law school classroom, maybe not.
Not a bit.
Not a bit, okay. Now, Gaithy, you've said it was once the war started. For the United States, that's December of 1941, so we're in the winter of early 1942. How did it begin, as you recall it?
Well, I guess our teacher had noticed we weren't saluting the flag, and she obviously told the principal, and so he was one that asked us about it and told him that he had orders from the Board of Education that if we didn't salute it, we would have to go home. But our teacher was very nice. She said if it was up to her, it wouldn't make no difference.
Okay.
But we just, according to the Board of Education, we had to go home.
Okay. Were there other witnesses who were school children in your Slip Hill school?
Not at our school,
not
but
at your school.
the community and the towns in town and rest of them around, there was several witness children at that time.
Okay. And according to your faith, what were you permitted to do, or what was your behavior while the other children would stand and salute the flag and recite the pledge?
Stand there very respectful.
Okay. But silently and not
Yes.
with your
Yes.
hand either at your heart or
That's right.
displayed
We
toward the
respect
flag.
the flag and what it stands for. We don't have anything against that. We just don't believe in worshiping or saluting it.
Right. Did the principal have an understanding attitude, or was he disapproving?
He was a little bit disapproving, more so than the teacher. He tried to tell us we needed to do it, but he wasn't really hateful or anything.
Okay. And I assume he reached out to your father to talk about this behavior problem of these girls.
No, not really.
I think he did go to the house once and talk to him, try to find out, maybe more than what we could tell him, but they told him the same things we had. So.
Right. So I don't mean to slight your mother in this. What was your parents' decision about how to handle this situation? The school has a mandatory flag salute, thanks to the state education department regulation, and you have your religious beliefs,
Right.
which are in
And,
conflict.
when we went home, of course, they understood and they said not to worry about it. And they got, our uncle helped us get a lawyer, Mr. Meldall in Charleston, which is a very understanding person, nice person. And he told us that we had to go back to school every morning for a while.
And why was that?
So they wouldn't fine our dad or put him in jail.
Okay.
Wouldn't say that we were just being truant, and that. So we went every morning, stayed till the flag salute, and they told us to go home. And said it was fortunate that we lived fairly close, so we didn't have a long distance to go.
Okay. And that was the end of the school day for you?
Yes.
Once the truant officer came and asked my mother why we weren't in school, because so she could say, well, we sent them and they sent them home. And
I
so
see.
that
Okay.
kind of took the, edge off of them. They didn't keep us home.
Okay. And were you aware that other school children were having similar experience?
Yes.
And the lawyer from Charleston, did he become involved in their matters too?
Yes.
Yes, he was the representative in Charleston. He contacted the lawyer for the Westchester Society, and they, I think, kind of coordinated the taking it to the courts
Is
there in
that when
Charleston.
Hayden Covington got involved in the case?
Yes.
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 He came to Charleston and
At
talked.
the beginning?
Yes.
But
And
when it got into the courts, when it
Right.
got far enough to get into the courts, yes.
some of the other children had a lot harder time than we did. In fact, our cousins, some of them weren't allowed on the school bus. They had good ways to walk, and then they are made fun of, and one of them got beat up. So, we had it fairly easy in that way, because the students in school we went, they didn't have anything else to do with us, but they weren't actually outright down mean to us, They just kind of ignored us. And
They weren't cruel or
no,
vicious
not like
or
some of
anything.
them were.
Right. What about the kids? How did your classmates treat you as this was all developing?
Well, curious, they were curious about it, and we talked with them, and but they weren't mean to us either. Like Gaithy said, they kind of ignored us some, but they weren't really mean.
We had a harder time after we got back in school.
Okay, well, let's get there in a moment. The period you're out of school is how long? Or, in and out on a daily basis, but largely missing school because of the flag salute.
Well, when it went in the West Virginia State trial, Supreme Court, they decided in our favor
Right.
against the school board. And so we got to go back to school the following fall.
Okay.
It was behind our class.
Fall of 42.
Yes,
Yeah, we were out from about the 1st of March to the rest of the year.
Okay.
That one's
And then you
School
were held
year.
back the next year? You
half a grade, yes.
half a grade.
And
Okay.
we had moved into Charleston in the meantime, and so we started a bigger school, a nice school. And when we first started, I know my mother went over to sign us up, and the teachers really didn't want us to come. They said, no, they can't come. And she said, yes, they can, because the Supreme Court, West Virginia, settled in our favor. And so she went and signed us up. And teachers didn't really, our teacher we had, she wasn't really one, I don't think.
She wasn't thrilled with us, in other
No, but
words.
she was just, she
But-
just kind of ignored us. She wouldn't really help us get caught up in our work or nothing. She said, no, it wasn't her fault. It was kept out, so we just had to catch up ourselves. So
And
we did.
was that what you dealt with for that entire next year? Which is the year that ends with the Supreme Court decision. Very interesting. Did you have a sense that the school system was doing something wrong to you, or was it just a situation that kind of was above your heads as girls?
Yes.
I think, though, we were really a little bit young to, I guess, think about the Supreme Court levels, and we just knew we couldn't go to school.
Okay. Did your parents think about it as a grave injustice that
No, not
they were
really.
experiencing?
They knew what was going on. That there's a lot of patriotism at the time, and people's emotions were running high, you know. And but they didn't have no ill feelings towards anyone.
Okay. In the community, did your family or extended family have experience with hostility, mobs, rough stuff?
No.
Any
Not
of the...
directly. We just heard about it. Some of them had a real bad time.